You're watching 6 News on Fox with Jasmine Stockings and meteorologist Carrie Cooper. This is the Evening News at 5:30.
Welcome back. It's not only hump day, it's time for Ask the Attorney, my favorite segment of all time. Gilbert Adams joining us as always. Thank you so much for being here.
Thanks for having me.
No problem. So let's get on down to it so we can make sure these folks get the answers to their questions. So the first question we had, if you only have a copy of a person's will naming an executor and not the original, is the will enforceable?
Well, there's a couple of questions on these issues tonight. First of all, you can have two types of wills in Texas. You can have what we call a holographic will, which is a will that's written out in somebody's own handwriting. Can't be anybody else's handwriting. And then you have a second will, which is typed, and that requires two witnesses that are identified at the bottom. So the question is, can a copy of either one of those wills suffice for the original? And the best practice is that you have the original. Yes. In most cases, you can use a copy if you have a witness who can say that it's a true and accurate copy of the original. Best practice, try to find the original.
Okay, so go ahead and search those documents.
That's
Next
right.
question. My ex-husband and I have a daughter, then he remarried and had 2 boys. Everyone has a great relationship and our daughter spends half the time with him. My ex and his wife are making arrangements for when they pass. They told my daughter that she would not get anything under her father's will since she was a beneficiary under my will. Can they do this? What rights, if any, does my daughter have? And should she contest the will?
Well, first of all, if you write a will, you can name your church, you can name just about anybody. You do not have to name your children as beneficiaries of the will. So the answer to the question is yes, he can exclude his daughter from the will. Now, that's if he has a will. If he dies, a lot of people confuse this with dying intestate or without a will, and if that occurs, there is provision for the assets to be divided equally among the children, for most of the assets, depending upon whether they have the same parents or not. But so, if you die intestate without a will, yes, some of that will go to the children, but otherwise, you can choose whomever you'd like for your property to go to.
Can you force somebody like your ex-husband to put your child or y'all's child in a will?
No, cannot do that. And the second part of that question was, can it be contested? And a lot of people think that you have different ideas about why something could be contested. A will can only be contested not because of what it leaves somebody or doesn't leave somebody, but if all the procedures, they can attack the procedures to contest the will, but not because of what it gives somebody or what it doesn't give somebody.
Gotcha. Last question, and we got to wrap this one up. I just got notice that a judgment was entered against me. Can my home be taken from me to satisfy or pay for my judgment, my car, my wages? In
Texas, we have very strong protections. It's called the homestead protection. And what that does is it protects your home from, it doesn't matter the value, it can be a $10 million home, and it can be protected, as well as retirement benefits, life insurance proceeds, and up to $60,000 in personal property, which would include a car. So no, that cannot be attached in response to a writ of execution, only assets outside of those areas.
Awesome. Thank you so much. Before, I know we have to dip out, but can you give us your information really quick?
Yes, ma'am. My number is 835-3000. You can reach our website, www.gta-law.com.
Thank you, attorney. We always appreciate you coming on the show. All right.